that was it. Just one time.
Okay. And when she was, did you have an occasion that time you were drinking with her to see what her demeanor was like?
Laid back. just cool.
I want to go fast forward to the night of November 1st, which was a Friday night, to
Yeah.
November 2nd of this year. Do you remember those dates?
Yep.
All right. On November 1st, that Friday night, was there a time that you talked to Renisha McBride?
Yes, it was. It was like around 6, about 6, 7. I was just getting off work because I had asked her if she could pick me up because my truck was in the shop, and she told me she was on the east side. And I was like, okay, well, that's cool. Then she was like, well, where do you stay at? And I told her where I stayed at, and then that was that.
6, 7, was that, excuse me, in the morning or was that in the evening?
In the evening.
So about 6 or 7 p.m. on November 1st, you spoke with Ms. McBride on the phone.
Yeah, we spoke on the phone and we texted.
Okay.
Cause we was texting at work. Well, I was texting her while I was at work, and then when I got off work, we was texting, and then she had called.
Did you know where, when you wanted a ride home from work, do you know where Ms. McBride was? You said in the east side. No,
On the east side. That was it. That's all she told me. It was just the east side.
And did you hear people in the background when you were talking with her?
Yep.
Do you know if they're male, female, what she was doing at that time?
I heard both parties, male and female.
Right. And how did Ms. McBride sound to you when you first talked to her about 6 or 7 p.m.?
She sounded okay. She wasn't, intoxicated or anything. She just sounded like she was just having a good time. But I told her, though, I'm like, I know you're on the east side, so be careful. If you don't know the east side, and I just be careful, and that was that.
Do you live in Dearborn Heights?
No.
No. Do you live in the area of Warren, Rather Drive?
I stay on Warren, West Warren, yes.
Okay. And what's the cross street?
I stay in between Southfield Freeway and Evergreen.
Right. Has Renisha McBride ever been to your house?
No.
That night on November 1st, was she planning to come over to your house?
Yeah, she was, but she told me she would come like around 9, about 9, 10 o'clock.
Did she ever show up at your house?
Nope, because I texted her phone and I called her phone and it kept going to voicemail. And that was like around in the midst of like 6, 7 o'clock. So.
Okay. And at that night, what was the last time you spoke with Ms. McBride?
It was a phone call. It might have been, I want to say like 9 o'clock when I told her to be careful on the east side.
Okay. On Friday night, do you remember making a statement to the police?
I own a small business, and I chose Blue Cross for health coverage.
Yeah, I told them everything that I'm telling you now.
Okay, and in that statement, did you say that it sounded like Ms. McBride had been drinking?
Oh yeah, it was around that time. Yep, I sure did tell them that.
Okay, and about what time? The 6 or 7 p.m.?
No, it was later on that night because I had called her and her phone was going to voicemail. And then when she finally picked up again, that's when she might have sounded she didn't sound like herself.
Okay, about what time was this when she didn't sound like herself?
Ooh, I really can't even tell you. I just know that first phone call we had was like around 9.
When you said Ms. McBride didn't sound like herself, what was different about her?
She had a couple, she was slurring. So she might have been drinking, but I don't know. I wasn't there, so.
And would it be fair to say that Ms. McBride sounded very intoxicated when you were talking to her?
Not very intoxicated, but I've been around her. We drunk like one time, and the one time we drunk, she did sing when we was together. I seen how she was when she was a little intoxicated. We both were, so. But.
And on this night, on November 1st, isn't it true that she sounded so bad and so intoxicated you were worried that somebody might have slipped something into her drink?
Yeah, I did tell the police that because I was worried about her. Because she told me she was on the east side, and I know Nisha. I'm like, I know she wouldn't drive all the way from the east side intoxicated like that. So that's why I was wondering. I hope nobody did nothing to her while she was over there for her to drive way back this way.
So it sounds like you were very concerned about her well-being because she sounded out of it when you talked to her.
Yeah, because she a good girl. So she looked out for me, and I always would look out for her.
Nothing further, Your Honor. Thank you.
Mr. Bynes, you indicated that when you and Renisha would drink together that she was not a mean drunk, right?
Yeah, no, she was just laid back.
And when you say laid back, you mean that she was nice and that she was friendly and that
Yeah.
she was drinking and having a good time.
Oh, yeah, she would crack jokes a lot when she got like that.
Okay. And she wouldn't be yelling at you or anybody else, right?
No, no.
She wouldn't be screaming, right? She wouldn't be trying to pick fights with anybody, right?
I called her an angel.
You called her Angel.
Yeah,
Because that's how she acted, right?
yeah, nice
Nothing
person.
further. Thank you, sir.
All right.
Nothing further, Your Honor.
You may step down.
All right.
Your Honor, the defense next call is Amber Jenkins. Oh, thank you.
Ma'am, please raise your right hand. You solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Okay. I need for you to speak nice and loud, okay?
Yes.
In that silver microphone. Thank you.
Good morning. Hi. Can you introduce yourself?
My name is Amber Jenkins,
Amber, how old are you?
18.
Do you know Renisha McBride?
Yes, it's my best friend.
And I want to let you know that we are very sorry for your loss. I know you were best friends with her. How long have you known Renisha?
Since I was in about 8th grade,
Would you see Renisha a lot during the year?
this past year,
Right.
we saw each other enough. We both were employed and I'm in school also, so we saw each other when we had the time to.
I want to take you back to November 1st, the Friday night of this year. Do you remember that night?
Yes.
Did you go over to Renisha's house that night?
Yeah, I went over there. We was chilling.
About what time did you go over to Renisha's house?
I believe I got there around 6, 7.
6 or 7 p.m. that night?
Yes.
And who was present at Renisha's house when you went there?
It was me, her, and I believe her grandma was in the back sleeping.
What did you and Renisha do when you got over to her house?
We were playing card games. We were playing shot games.
What are shot games?
The loser takes a shot. We were playing
Shot.
card, yeah.
And a shot of what?
Of liquor.
Okay, what kind of liquor were you drinking that night?
In New Amsterdam,
Is that vodka?
yes.
And was Renisha drinking that night?
Yeah, we both were.
And with this shot game, that night you were winning most of the card games and having Renisha drink, correct?
It was, I believe I was winning. It was we both were drinking, but I believe I was winning because she is a sore loser, and that's why we got into our little argument, I guess you can call it an argument.
Okay. Renisha got mad at you because she thought you were cheating at the game, right?
I really don't know why she got mad, or I don't even know if she was really mad. I just know that we both started getting loud with each other, and that's my best friend, so I wasn't trying to argue with her or nothing like that. So I just got up and left, and I told her that I'll call her tomorrow, and then she said okay, and then that was just it.
So you felt like you had to leave Renisha's house because you didn't want things to escalate into a big argument?
Objection.
No,
Committee.
I didn't.
Not for the sister.
Had you ever had, in the time since you've known Renisha, since she was in middle school or elementary school, did you ever have to leave her because you were about to get in a fight?
No.
And was this the first time?
Our first little argument, yeah, it wasn't even really an argument. We both just started getting louder and louder, and I was getting a headache, so I just told her I'll see her tomorrow. And when I left, she went in the house and closed the door.
On that night when you were with Renisha, approximately how many shots of vodka did she have?
I'm not aware of that. I don't know.
Did you see her drinking when you were with her?
Yeah, we were in front of each other. It was just me and her sitting at the table.
And if you don't remember it, does that mean you weren't counting the number?
No, I was not counting.
Okay. Did you start off with a full bottle of vodka?
Yeah.
And do you remember how much vodka was left when you left Renisha's house?
About half of the bottle.
And what kind of bottle was it? A pint?
The $12 bottle.
A $12 bottle of vodka, and about half of it was gone by the time you left Renisha's house?
Yeah.
Approximately how long were you at Renisha's house?
Not long. It was about, I left, it was like 9 o'clock, 9:30. I left.
And besides drinking vodka, did you or Renisha smoke anything?
Yes, we had about 2-3 blunts.
Okay, and what is a blunt? Is that a marijuana cigarette?
Yeah, marijuana.
Okay. And Renisha, you had 2 or 3 blunts between you and Renisha that night?
Yeah, passing it back and forth. Yeah.
Nothing further. Thank you.
Ms. Jenkins, you indicated that you and Renisha have been best friends since about the 8th grade or so?
Yes.
So is it fair to say that you hung out together on a number of occasions over that period of time?
Yes, it's just recently since I graduated high school, we both got jobs and, stopped hanging so much. But otherwise, we was with each other almost every day.
And how old are you?
I'm 18.
And you indicated that you were both drinking that night?
Yes.
And when you left, Renisha went back into the house and closed the door,
Right.
right? And when you left, you said, hey, I'll call you tomorrow.
Yes.
Okay. Was she wasn't cursing at you?
No,
right?
we wasn't calling
attempting
each
to
other our
fight you?
names or nothing. No, we were just getting loud. Like she was like over a deal, and I'm like, bye, and that's it. It wasn't no bad names or nothing.
All right.
No, she wasn't all in my face or nothing like that.
Okay. And so the last time that you saw her or spoke with her would have been at about 9:30 that evening?
Yes,
And
about
then you
9.
left and you went home and...
Yep, I went home, and I thought she was staying home too. She went in the house and closed the door.
You indicated that there was nobody else at the house except for the two of you and then her grandmother, who you believe was asleep in the back bedroom.
Yeah, she stays in her room. I come over there. She usually takes care of her grandma. I come over there and help her every now and then. She really just stays in her room, watch TV.
Okay. Thank you. I have nothing further.
Nothing further, Your Honor.
You may step down.
Okay.
Your Honor, at this time we'd like to recall Detective Sergeant Burke.
Sergeant, I remind you, you're still over the oath, okay?
Yes, Your Honor.
Good morning. Would you please identify yourself to the court?
Detective Sergeant Stephen Gurka.
When you previously testified, I cannot recall if it was on direct examination of Ms. Clark or my cross-examination of myself. You said that when you took prints from the front and side doors of Mr. Wafer's house,
Yes.
Part of the fun of giving is trying to...
captured some handprints, side of the hand,
Smudges.
smudges. I'm sorry, yes, that's. And do you have those with you?
Yes, I do.
May I approach this? Now, we'd like to have these marked as...
There would be 2 smudges and then what could be maybe waffling from the screen if it was pressed up against the door. So it'd be 3 lifts altogether on one evidence tag.
Yes, and you can put it right under that plastic. Thank you very much, Detective. You just indicated to me what these were. Could you please go through those 3 separate print?
Yes.
What do you call those?
Print lifts.
Print lists.
Yes.
Thank you.
So this is on evidence tag 91819. These were lifted by Corporal Parinello in my presence. The one lift, this would be the waffling. It says front door, right side of pane.
Yes.
The next one says side door, right side panel.
Thank you.
And then the last one says side door above the knob.
Did you turn these over or show them to your fingerprint expert at the department?
Corporal Perinello, I asked him to take them to the lab.
Yes.
And what happened was he had not. He had actually checked them into evidence.
Yes.
If he had kept them, he could have taken them to the Dearborn lab and had them examine it. When he put them into evidence, I didn't know that, and I needed to. I'm the only one that can sign out this evidence. So they could be looked at by the Dearborn lab.
But to date, they have never been taken.
They have not, no, sir.
Do you know, from your experience, you've been an officer for how long?
26 years.
26 years. During your 26 years, have you ever had any of these smudges identified?
No.
Can the lab tell if it was a man or a woman smudges?
No.
No. And these were all that were lifted by
Corporal Perinello, yes.
these three? And he said one was consistent with the screen banging the door?
Objection, that's hearsay.
Oh, sorry.
Sustained.
Okay, I have no other question.
Detective Sergeant Gurka, you can't even tell us whether or not those smudges were made by a human being, can you?
I couldn't.
Thank you, I have nothing further.
You may step down. Any other witnesses?
No, Your Honor. Actually, no, we don't. But we do have a request to play the videotape statement.
Judge, under what theory of admissibility is the defendant's videotape statement admissible as evidence for the defense? It's the people's position that he has every opportunity to take the witness stand and be subjected to cross-examination just like every other witness in this case. The videotape statement is not something that is subject to cross-examination, and it's not admissible by them. Bottom line.
You start with what theory?
Your Honor, the theory would be rule of completeness. There is no right to confront at a preliminary exam stage, so that's not an issue. What we want the court to hear is the whole story and what happened that night. And it is in the videotape statement that Mr. Wafer went, and within an hour of the incident, he went down to this police department and made a statement to one of the officers here. It lasted approximately an hour. And I believe under the rule of completeness, so the court has everything, not just snippets. And when I'm talking about the snippets is the 911 call. We heard it played yesterday, and all we had was, hello, I just shot somebody, somebody's on my porch, and bang. And that's all we heard. And the rule of completeness, I believe, would allow that the videotape statement from Mr. Wafer come into court, because we didn't get the whole story from that 911 tape. And I know usually the rule of completeness is that you can't pick and choose. Let's say if you entered the videotape statement into evidence, I couldn't, and the prosecutor couldn't just pick and choose different parts of the statement to play. They have to play it all. And I believe that also is applicable in this case, that they can't just play the 911 tape. I think the rule of completeness allows his statement to come in. The purpose, and that rule is Michigan Rules of Evidence 103, the court rule. Purpose. The rules are intended to secure fairness in administration, elimination of unjustifiable expense and delay, and promotion of growth and development of the law of evidence to the end that the truth may be ascertained and proceedings justly determined.
And what about the right of the prosecutor to cross-examine? How do you cross-examine a piece of paper? Don't they have the right to cross-examine?
Your Honor, I couldn't cross-examine the 911 tape that they entered into evidence. I didn't have a right to cross-examine that statement. And we had the 911 dispatcher who took the call, but he doesn't know what was going on in Mr. Wafer's mind. And we even had an argument yesterday where, well, it didn't sound like Mr. Wafer was startled. And
Well, that's up for me to make that decision. But this is a statement that you're flying.
And so was the 911 call, Your Honor.
Well, it speaks for itself.
And I don't think it does, and that's my argument.
Ms. Clark?
Judge, the rule of completeness says that it needs to be, if I were to admit, let's assume that there's a written statement that goes along with this videotape statement, and there's not in this case. But if I wanted to simply admit the written statement, and defense was saying, but there's so much more conversation between the police and the defendant during this written statement, that in order to be fair, in order for it to be complete, we have to play the video. Okay, fine. Then we have to play the video. But that 911 call comes in as a statement by a party opponent under 804. It also comes in under the, not necessarily present sense impression, but it's a statement that was made by the defendant. It's initiated by the defendant. He's the one that calls 911. The operator authenticates the 911 call by saying, that's me, that's the person that I spoke to. And then the defendant ends that conversation by hanging up the phone. It's clear from the 911 call that the dispatcher is attempting to get even more information about what city do you live in when the defendant hangs up the phone, says thank you, and hangs up the phone. Now what they're seeking to do by saying that this court needs the rest of the story is make it so that I can't ask the defendant about what happened that night. If they truly were interested in getting the full story to this court, the defendant would be seated in that chair right there and he'd be telling you what happened. This is a backdoor attempt to violate the rules of evidence. And in fact, there's case law that says that that's not allowed. It's simply not allowed. And I think it's Rule 106 is the rule of completeness, but it does not compel admission of otherwise inadmissible hearsay evidence. And there's a line of cases. In fact, I have People versus Granberry, where a defendant makes a statement during a search warrant, hey, look in the chimney flue, because that's where the heroin is at. And then later, shortly thereafter he's arrested, he makes a written statement denying possession of the heroin, and the court says no, that you don't get to, under the rule of completeness, make the prosecution put this self-serving statement in, or even allow the defense to put the statement in. In that case, the defendant contended that the written statement should have been admitted under the rule of completeness. And the court says that no, under MRE 106, the purpose of the rule of completeness was to prevent unfairness which may result if a statement is taken out of context. Defendant's written statement that the heroin did not belong to him did not provide context for his verbal statement to the police that the heroin could be found in the chimney. Nor does defendant explain how his verbal statement that the heroin could be found in the chimney would have been made complete by the introduction of his written statement. Rather, the defendant merely argues that his written statement should have been admitted to rebut any implication of guilt. In this case, the 911 call speaks for itself. It doesn't need further statements to complete the context. That's ridiculous. A statement that's made almost 2 hours later is simply a statement made by the defendant. And it's not admissible by the defense. If I wanted to put it in, I could. But that's my prerogative. The rule of completeness does not generally allow a defendant to admit his own out-of-court written statement to clarify or add context to a prior verbal statement. Moreover, the fact that the defendant's written statement suggested that the heroin did not belong to him would not have disproved the element of possession in this case. Meaning, these two statements, the 911 call and the defendant's alleged statement to the police, don't ever say that he didn't shoot her. So if they truly want the full story, then he can get in the chair and be subject to cross-examination, Judge. I don't see any rule of evidence that allows for the admissibility of it, and I would ask that you deny their motion.
Your Honor, may I make one additional argument? I realized this yesterday. The prosecutor just stated that the 911 operator authenticated the statement. What we're missing here is anybody identifying Mr. Wafer's voice on the 911 tape. We don't have any evidence presented in court which will identify Mr. Wafer as the shooter. We have a 911 call, but he didn't say this is Ted Wafer, he gave an address. We don't have that. If the videotape statement is played, the prosecutor might get that element. And honestly, the defense doesn't want this to get dismissed because we don't have probable cause on who did it.
Judge, I appreciate that she's trying to do my job for me, but quite frankly, the defendant in their own questioning of the 911 call said, you had a conversation with my client. But the reality is that the defendant is the only person that's at the house at 16182 on Outer Drive. And that the 911 operator says, I called him back and I advised him, hey, come out the side door. And what happens? The defendant comes out the side door. Nobody else at the home, nobody else comes out, nobody else is at the home except for the defendant. Shot with a shotgun? Oh, look, there's a shotgun laying there. So really, are we going to argue about identification? That's ridiculous.
Your Honor, it's simple facts. No one identified Mr. Wafer. There was no voice analysis that Mr. Wafer talking. Mr. Wafer could have come home in the interim after someone else had called using his phone. There's been absolutely no evidence presented that Mr. Wafer was involved in the shooting. I think that I agree with my co-counsel. This video, taken by a trained police investigator who does this, that's his job.
Judge, at this point, I'm going to object because I think that once you start the argument, it's got to remain with that same lawyer. And to have them bouncing back and forth, it's simply not.
I'm only doing this because I cross-examined Mr. Peppers.
Well, I don't think there's any rule that once you start, you have to finish.
But I think this would complete that identification of who made that 911 call because that's discussed in this interview.
Well, I'm reading Rule 106. Entitled remainder of or related writings or recorded statements. The rule of completeness. Now, if I can sit here and tell you I know 100% that I've had this issue before the court before, no, I can't tell you that, but as I'm reading Rule 106, I take it to mean if there was a 911 call and certain parts of that 911 call were introduced into evidence and other parts were not, then the rule of completeness, as I read it, would state, hey, the rest of the conversation, this 911 call, should be heard as well. We're talking about separate statements here. We're talking about a 911 call and then now a separate recorded statement altogether. You know, I would tend to agree that I don't think Rule 106 applies in this situation as you're asking the court to apply in this carpenter. I do believe that that statement, if you want those statements to come in, I believe that the defendant's going to have to testify as such to give the prosecutor a chance to cross-examine the defendant. Therefore, I'm not going to allow the statement.
Thank you.
Anything further?
Just arguments regarding bond over.
Are we ready to do that, or?
Yep, I'm ready to go. Judge, as you are fully aware, the standard in this case comes from People v. Doss at 406 Mich 90. Felony, I have to establish first that a felony has been committed and that there is probable cause to believe that the defendant committed it. Positive proof of guilt is not required, but there must be evidence on each element of the crime charged or evidence from which those elements may be inferred. A magistrate should not discharge a defendant when evidence conflicts or raises a reasonable doubt of his guilt, because such questions should be left to a jury at a trial. The defendant in this case is charged with first count 1, homicide, second-degree murder. The elements that I have to prove are first, the defendant caused the death of Renisha McBride. That is, that Renisha McBride died as a result of a shotgun wound. There's no question that it's the defendant in this case who caused the death of Renisha McBride. We've heard that 911 call where the defendant says to the operator, I just shot someone on my porch with a shotgun who was banging on my door. We've just discussed the identification of the defendant. The testimony at the preliminary exam was that the 911 operator called the defendant back on a number that he had originally called on, that he gives the address of 16812 West Outer Drive, that phone call comes in at 4:42 a.m., and that the first officer responds to that location in 1 minute and 4 seconds. A minute and 4 seconds later, the dispatcher says that he can hear on the radio that officers are arriving at the scene, and he advises the defendant to come out the side door of the home and to speak with the officers. And that's exactly what happened. The defendant was the only person who came out of the home at 16812 West Outer Drive, and that the officer spoke with him and secured him in the back of their patrol car. There was nobody ever else at that location, and so this court can see that it is the defendant. The second element that I must prove to you is the intent. I have to prove either that the defendant intended to kill, or he intended to commit great bodily harm, or, what I believe in this case is most applicable, the defendant knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. And the facts that were established at this preliminary exam is that the defendant took a shotgun out of a case that was found in a back bedroom, that the shotgun was loaded, it was wrapped in order for it to be loaded. The defendant took the safety off, he carried that weapon to the front door, he opened that front door, he pointed it at a young girl who was standing on his porch, he shoved that shotgun in her face, and he pulled the trigger. There's no question that he killed her through the locked screen door. Now, whether or not that screen was in or whether it was out, the shot came through a locked screen door. Those actions show that the defendant created a very high risk of death. Dr. Petzer testified that the shooting was instantaneous and that no one could survive from that. His actions of obtaining that gun, shoving it in her face, and pulling the trigger, which is what is required in order for that gun to discharge, show that he created a situation where at the very least great bodily harm was going to occur. Furthermore, this court should look at CJI second 16.21. Court may infer that the defendant intended to kill if he used a dangerous weapon in a way that was likely to cause death. Likewise, this court may infer that the defendant intended the usual results that follow from the use of a dangerous weapon. And a gun is a dangerous weapon. Shotguns are designed to kill. That is their only purpose. Whether you're killing human beings, or rabbits, or deer, a shotgun is designed to kill. Count 2. I have to show the defendant in this case is charged with homicide, manslaughter, death by weapon, aimed with intent without malice. I have to first show that the defendant did injure Renisha McBride. No question about that. Second, that injury resulted from discharging a firearm that was pointed at another person. Everyone testified that this shotgun had to have been pointed at Renisha McBride when the trigger was pulled. And finally, I have to prove that the wound resulted in death. The shotgun wound is what ultimately killed Renisha McBride. Finally, the defendant is charged with weapons, felony, firearm. Simply have to show that the defendant committed a felony and that he possessed a firearm at the time. There's been no question in terms of count 1 and count 2 that those are felonies and that the defendant in fact possessed the shotgun. Based on all of that evidence and the law in this case, I ask this court to bind the defendant over as charged.
Thank you, Your Honor. In this case, there is a big problem with the murder charge. This court has to find after the preliminary exam that there was intent on Mr. Wafer's part. And there is no evidence that there was intentional killing in this case given by the prosecutor's office. We do not have that. There were 2 people there that night. And unfortunately, Ms. McBride can't say what happened. And we now haven't heard anything from Mr. Wafer what happened. So everything that we're thinking might have happened on the porch is speculation. There is nothing, you haven't gotten evidence, Your Honor, to infer that intent. What we do have is we have a young woman who started at approximately 6 p.m. drinking alcohol heavily, smoking marijuana. We have her sounding really out of it, not acting like her normal self. We had 2 witnesses who just testified this morning saying that. We also have at about 11:30 p.m. that night a horrific car accident. You saw the shatter on the windshield from her head. And we have somebody who was disoriented, who could have been, and you heard the medical examiner saying, somebody who suffers from a brain injury can exhibit signs of aggression, of confusion, and that's what we have here. So what we do know is that there was a young woman out there. We don't know what was happening in those 3 hours, 4 hours between the time of that horrible car accident and the time she arrived at Mr. Wafer's house on the front porch. But what we do know from the evidence presented here today and yesterday about what happened when she got to the home, we heard Mr. Balish say with absolute certainty that screen frame was down. It was knocked out of the frame prior to the shooting. We just had Detective Sergeant Gurka admit into evidence waffle marks on the front door. Waffle marks meaning, which supports Mr. Balish's testimony yesterday, that it would have to be caused by somebody banging to put the waffle marks on the door. We have not only that, we have evidence that on the side door of Mr. Wafer's house, there are smudges. And Detective Sergeant Gurka testified that we can't identify, we can't say they're Miss McBride's handprints, but that's what it looks like. We can't tell if it's a man or a woman who did it, but it looks like somebody banging like that on the side door. So not only do we have a broken screen door in the front, waffle marks on the front door from the screen, we have smudges on the side door. So we have evidence that this court can consider that shows this wasn't intentional. And the prosecutor wants to say that we had evidence that Mr. Wafer took off the safety, pointed it at Renisha, shoved it in her face, and pulled the trigger. Who said any of that? Nobody. That's not, you can't even infer that from the evidence. You can't infer we don't have any evidence the safety was on or off before Mr. Wafer got the shotgun. We don't know if the bullet was already in the gun. We don't know if Mr. Wafer had to rack that gun. We can infer from the evidence he picked up the gun, fearing for his life, hearing people break in and banging on the side door, then coming to the front door, breaking a screen door, grabbing a weapon, running to the front door. And we don't know if he knew somebody was out there right at that moment at the front door, because there's banging on both doors. And that's a reasonable inference from the evidence just presented at the preliminary examination. And to infer that he took the safety off, he had his finger on the trigger on the way there. You heard Detective Sergeant Gurka state that when I put that in my search warrant request, I just speculated. We didn't have any evidence that he had his finger on the trigger when he got the gun all the way to the front door. That's not in evidence, and that's actually a misstatement in a signed, sworn search warrant. And there's no evidence that that's what happened. So, what could have happened at the front door? Who knows? Ms. McBride could have. We heard evidence that it was a shot, close range. We heard Mr. Balash saying it was extremely close range. So it was 2 feet or less. He can't tell you how much less it was. We have the medical examiner who testified he believed it was 3 feet or less that the shot was done. Which, for your honor to consider, what could have happened? It's so close range. That is enough time for Renisha to try to grab the gun. That is enough time or something. And I'm not saying that's what happened. But we don't have evidence to the contrary at the preliminary exam, Your Honor. The prosecutor has the duty to show you there's probable cause, there was intent. Intent to support the murder 2 conviction or the murder 2 charge. We don't have that. We have speculation, and you can't bind over on speculation. You can bind over on reasonable inferences, but there's not even enough to give you reasonable inference that Mr. Wafer intended to point the weapon and pull the trigger. We don't have that at this preliminary exam. And I've got some case law, Your Honor, which supports this. Exactly, I mean, it's not exactly the same, but very close, where district courts, just as yourself, have held at a preliminary exam in cases there was an intent for murder 2. There was enough to bind over on voluntary manslaughter, but not for the murder 2 offense. The first one is People v. Neal. The site is 201 Mishap 650. It's from 1993. Michigan Court of Appeals held that the district court did not abuse his or her discretion by not binding over on murder 2 and just binding over on voluntary manslaughter. In this case, it was a firearm. It was a shot in that court. The prosecutor said, well, you can just infer since there was a deadly weapon used, that's enough for intent. That's not the law, Your Honor. That's not enough to show intent. Because in People v. Neal, what happened was that The defendant, Mr. Neal, in this case, is an African-American man. He was getting racial epithets thrown at him at a fair. One of the decedent went up and attacked one of the defendant's friends, not him. The defendant had a gun, pulled it out, did warning shots, and he ran to his trailer. And there was conflicting evidence at the exam in Neal where it said that the decedent turned around a little bit, like he was chasing the defendant, chased him to the trailer park, and when he got there and saw the weapon, that the decedent turned around. Even with that evidence at the preliminary exam, the judge found there wasn't enough evidence presented by the prosecutor. There was intent to bind over a probable cause on murder too. And this was upheld by the Michigan Court of Appeals, and part of this opinion says that the inquiry is not limited to whether the prosecution has presented evidence on each element of the offense. The magistrate, or the judge in this matter, is required to make his determination after an examination of the whole matter. Although the prosecution has presented some evidence on each element, meaning intent, if upon examination of the whole matter the evidence is insufficient to satisfy the magistrate that the offense charged has been committed and there's probable cause, then it should not be bound over. In Neal, the court, I think, on more facts to show intent than in this case. We had somebody firing warning shots. We had somebody who we think the decedent turned around. We had no evidence of that in this case. It was a straight-on shot, very close range. And there was an intent in this case to bind over on murder too. So there shouldn't be intent on Mr. Wafer's case to bind over on murder too. And then one more case, Your Honor, People v. King. It's 412 Mich. 145, that's from 1981. This was a case, another case where at the preliminary exam, the district court said that the murder one charge wasn't proven by the prosecution. There wasn't evidence of intent. They bound over on manslaughter only. Same thing as Neal and same thing I'm asking in this case, Your Honor. In King, the defendant killed the decedent. It was a jealousy thing. It was two men jealous of another woman, and the defendant killed the decedent and shot through the door, just like this case, and that the district court found that there wasn't probable cause. Just because there was a shooting with a deadly weapon, that's not enough to bind over on intent for murder. And the same is here. What do you have to show intent? Besides that there was a shotgun and it was fired. And we don't even know that, Your Honor, because remember when the firearms expert from Michigan State Crime Lab testified, he said, it's possible if you drop that weapon, it could go off. He said that. He testified to that. So we don't know what happened on that porch. There wasn't evidence presented to prove intent, the probable cause standard. And I know it's a low standard. It's more likely than not. It's way less than beyond a reasonable doubt. But we don't even have enough here to bind over on probable cause for murder too. Your Honor, I have arguments for all the charges. Do you want me to go on to that, a different theory?
Well,
okay. I didn't know if you wanted to let the prosecutor respond to that. My other one, I believe that you should not bind over on murder too because the prosecutor hasn't proven intent. I don't believe the second defense argument is that you shouldn't bind over on any charges because of the Self-Defense Act of 2006. In that case, in that law, gave a right to a homeowner and to people who are in fear of great bodily harm or death or sexual assault, which wasn't the case in this instance. The right to use deadly force. If somebody is breaking into their home, there is a presumption that the homeowner can use deadly force. That presumption applies in this case, Your Honor. We have evidence, and everybody's looking at this case from Ms. McBride's eyes. And at the start of this case, we had this young woman who was walking around looking for help, knocking on doors. We don't know how she was. We have evidence to the contrary. We have somebody, and unfortunately, she got a series. I don't know what happened to her in the car accident, what happened to her brain. at that time, but something happened from the witnesses who testified when she got out of the car. She wasn't in her right mind. And then we had her two friends earlier in the day saying that this wasn't the Renisha we knew. Her best friend since middle school says, this is the first time I've ever had to leave her because I didn't want an argument to escalate. And then we have the man, Mr. Vines, she knew from work, who said she sounded I was worried about her, and he's been out with her drinking before, and she sounded so different that night that he thought somebody slipped something in her drink and warned her to be careful. So we have a young woman who is not in her normal personality, normal demeanor. And I'm not saying anything, and I'm not trying to put her down or say that she caused it. I'm not, Your Honor. But instead of looking at through her eyes, we have to look, for Self-Defense Act of 2006, we have to look through the eyes of the homeowner, the reasonable person. Would a reasonable person have used deadly force? So we have to look through that. And if you look through that lens, we have 4:30 in the morning. We have a person alone in the home. We have evidence the screen frame was so violently banged that it broke. So if you're at 4:30 in the morning by yourself hearing that at the front door, what do you think's going on in your mind? What do you fear you think's going on? And then, what if somebody's at the side door? Not only do you have somebody banging, crashing the screen, leaving the waffle marks, you have somebody on the side door leaving smudges of banging. So now the house is surrounded. You don't know how many people are out there, what's happening, and you can infer that, Your Honor, because we heard the evidence. And you can infer that there's banging on the side, there is violent banging to break a screen on the front door. We have a man alone in his home. And when you have evidence that there could have been a breaking and entering, there is a presumption now that is afforded to the defense. We are given a presumption under the Self-Defense Act of 2006 that now it's under, MCLA 780.951, presumption regarding use of deadly or lesser force in defense of self. It's a rebuttable presumption. In a criminal case, that person who uses deadly force under the Self-Defense Act had an honest and reasonable belief that imminent death or great bodily harm, it doesn't have to be death, it can be, I'm afraid I'm going to be seriously injured, will occur if both the following apply. The individual against whom deadly force or force was used was in the process of breaking and entering a dwelling, and the individual using deadly force honestly and reasonably believe that the individual is engaging in the conduct described, so that the homeowner honestly believes somebody's trying to break in. Who wouldn't honestly believe that?
Well, doesn't that give rise to the question of fact?
No, Your Honor, I believe that we have this, it gives rise to a presumption. And why that's important is because when this presumption arises, the burden shifts back to the prosecutor to prove it was not self-defense. And that is in that Self-Defense Act, where now the prosecutor's got to rebut the presumption that Mr. Wafer lawfully used deadly force. They have to show it wasn't justified. And that applies to a preliminary exam hearing, Your Honor. It's not a question of fact. If you believe that the Self-Defense Act is justification and does protect Mr. Wafer, you can use that at a preliminary exam, and it doesn't have to be a question of fact. You can decide it. So there's two arguments from the defense. Once the prosecutor has not proven intent to support a murder to bind over, and then for all charges, Mr. Wafer was justified using deadly force.
Thank you very much. Ms. Clark, talk to me about the intent.
Sure, I will. And I actually have case law as well, Judge. I have People versus Jackson, and that is at 63 Mishap 249. It's a 1976 case. In that case, I believe the facts are more on point than what defense counsel cited. In terms of this case, this Jackson case, the facts are as follows. At 2:51, decedent went to the residence of Richard Holmes to purchase narcotics. Wilson knocked on the door while Lewis stood on the porch. Defendant stood on the steps leading to the porch. Holmes opened the door and told Wilson that he did not know Lewis. Wilson made a move. Holmes jumped back into the hall. There was a shot that came from the hallway, and defendant returned fire with a shot-off shotgun. In that case, the court indicated that the trial judge had inferred malice from defendant's use of a sawed-off shotgun. We recognize that the finder of fact may infer malice from the use of a deadly weapon. There's no question in this case the defendant used a deadly weapon. And he used it in the manner in which that type of weapon is supposed to be used. Now, defense counsel says there's no evidence that the defendant loaded the weapon, that he racked it, that he took the safety off. But the reality is that that weapon only fires when all of those steps have been taken and that the trigger is pulled. Their own expert said that gun is not simply going to go off. In fact, I asked him, would it be reasonable to have this drop test that defense counsel was asking Detective Sergeant Kalanic about? And Balish says, no, it would be ridiculous to even do that. In this case, that would be ridiculous to even do that test. Their own expert says that. The only way that this gun goes off is if the defendant pulls the trigger. When you aim a gun, even if you just point it at somebody's head and pull the trigger, that is a situation where great bodily harm is likely to occur. And it doesn't take rocket science for somebody to know that. It doesn't. You point a gun at somebody, you pull the trigger, and it hits them in the face where you pointed that gun, that is a situation where death or great bodily harm is likely to happen. And that is the third prong, the intent prong of murder 2. There's also People versus Wiggins. It's an unpublished at 1997. Westlaw 333-53472. It's a mishap. And I understand that it's not binding on this court, but it certainly it should give it some weight. Where it indicates that a shotgun fired at close range, a person can infer malice. In this case, the defendant caused the death of the decedent by shooting him. Defendant's malice or intent to create a high risk of death or great bodily harm with knowledge that death or great bodily harm will be a probable result could be inferred by the fact that the defendant pulled out a gun and shot the decedent at close range. We all admit that this was, in fact, within 3 feet. Whether it was in 1 feet, 2 feet, or 3 feet, it certainly is within close range. It has to be based on the size of the porch and even the size of the vestibule where the defendant was standing. So I have copies of both of those cases. In terms of the intent angle, quite frankly, I don't believe that there's any evidence that supports a break-in. We've got evidence that she's banging on the door. Furthermore, that screen insert is the only part of that screen that came out. And it was not damaged. And we know that it was being held there by one little plastic tab. Probably would have been enough to knock it out. And we know that she's banging on the door. There's no damage to the frame of the screen. There's no damage to the door handle. There's no damage to the door behind that. There's no damage anywhere except the screen has been knocked out. And whether or not it's been knocked out because of the defendant firing a shotgun through it or because this girl knocked it out, that's a question of fact for a trier of fact. Defense counsel then moves on to the Self-Defense Act. Well, there has to be some evidence that the defendant is reasonably in fear. There's no testimony that the defendant is in fear, and there's no testimony that his fear is even reasonable. Defense counsel wants to say that there's banging at the front, there's banging at the side. There's been no testimony that there was ever any banging at the side. And that he's so in fear of his life, what does he do? He doesn't pick up the phone to call 911 to call the police who respond within a minute. No, he's going to open up a door where he's safely ensconced in his own home and invite the unknown number of people, the unknown number of threats. I'm going to invite those folks into my home. That is ridiculous. That's ridiculous. You open up the front door because you're so afraid of whatever it is that's out there? That doesn't make any sense. That's not reasonable. And you have to be reasonable. Even under the Self-Defense Act, it must be reasonable. And his actions, according to what they say he did in their argument, that's not reasonable.
Okay.
Your Honor, may I add a couple of, I know you've been patient. I just wanted to say for Jackson, the case the prosecutor cited, that was a sawed-off shotgun. That was illegal. I think just from being it sawed off, you can infer intent and malice, and you saw off a shotgun so you can kill people. In this case, we heard testimony, the shotgun Mr. Wafer had was legal. He legally owned it in his house. It wasn't sawed off. That's a big distinction, Your Honor. Okay, and then, that'll be it. Thank you, Your Honor.
All right, give me a few minutes. I'm going to go back, look at some of these cases, and I'll come back and I'll make a decision. Okay? Court is adjourned for a few minutes.
Sticking here for a little bit.
Be the green one. Unless he wants to know that I'm not really. Who does? That's good enough for me.